hope it will be interesting. A very short and brief introduction from me. Why this topic? Why sustainability? The fact is, when Paolo Bucci-Rossi contacted me and asked to propose to organize a panel in the context of this beautiful festival, I remember a call I had with Suzanne. It was, the typical boring presentation that we make to our client. And after our presentation, the only comment from Suzanne was to keep her updated on any possible intersection between sustainability and antitrust. Why? Suzanne Wagner is the head of antitrust at Clariant, and obviously for them this is a real issue. And so at that moment I have realized that this was not just an academic curiosity, but a real issue. And let me say that after this summer we have enough evidence that this is a real serious issue. And so I thought that this panel was a perfect and a good occasion to understand, to discuss about this topic. Obviously, I needed to find the real expert. I had already Suzanne Wagner, and I had to find someone from the private practice, so I contacted my colleague Francesca Miotto. She's based in our Brussels office. She's doing mostly behavioral matters since now 15 years. And she advises our client in cases and projects which basically touch on this issue, sustainability. To complete our panel, we need to hear from the European Commission, and we have the privilege to have here only connected online remotely Jérôme Capéo. Is a policies officer in the unit in charge of the horizontal block extension regulation, and he is responsible for the new section on sustainability agreement, which will be contained in the revised version of the horizontal guidelines. We have to say that it's not present, not because it didn't want to come here, but because there is a restriction imposed by the European Commission discriminating antitrust conference, and we will make a complaint. But unfortunately, this is the situation. Last but not least, we have Cristina Volpin. She's a competition policy expert at the OECD. She's advising on sustainability, and since, let me say, the global nature of this issue, we thought that it was very helpful to have her in our panel. One caveat, our panel will only focus on sustainability agreement. We are well aware that this topic and a number of other intersections between sustainability and antitrust, but obviously the time is limited. We have organized the panel as follows. Francesca will start setting the scene and discuss which are, in her view, the most relevant topics. Then we will hear from Jérôme the approach from the European Commission. Cristina will expand on this, and then Suzanne will explain what the industry is doing, and most importantly, which are the challenges that the companies like Clariant face when they want to implement a project on sustainability, cooperating with competitors. After this initial introduction, we will have a discussion which I will try to animate. But please, this is for you, and so any possible question that you will have after the initial presentation, please do not hesitate. Raise your hand, make your question, don't be shy. I think if it will be interactive, it will be even more interesting. So I leave the floor to Francesca.
Thank you, Emilio. So indeed, as Emilio said, to set the scene for our discussion today, I'd like to summarize the state of play in the ongoing debate on the topic of sustainability and competition law. Much has already been said on the topic. I will not dwell on the more theoretical questions that dominated the debate in the beginning. What I would really like to focus on is the status of the debate in the EU in terms of how sustainability agreements should be assessed under the competition rules in practice. So how do competition law and sustainability intersect in practice? Sustainability is clearly a parameter of competition. Any agreement between companies not to compete on how green their products are certainly would fall foul of the competition rules. And indeed, over the years, there have been a number of cases in which the Commission has taken enforcement action against these types of cases. Just to mention perhaps the most well-known one, the car emission cleaning cartel, or otherwise known as the AdBlue cartel, in which the Commission in July of last year imposed very significant fines, I think fines totaling €875 million on car manufacturers who allegedly colluded and agreed not to exploit or limit the exploitation of the green potential of technology that was relevant to the reduction of the harmful emissions. Other cases, just to note, are, for example, the trucks case, where again the Commission took the view that the truck manufacturers agreed to delay the introduction on the market of green engines. Another notable case is the detergents case, which dates back to 2011. And also there is a pending investigation by the Commission into alleged collusion between car manufacturers, again, in relation to the recycling of end-of-life vehicles. So all of these cases have in common the fact that they involved collusion in the context of environmental initiatives. And these cases show that the Commission has long been using competition law as a sword in the fight against collusive arrangements that masquerade as environmental initiatives. Also, what these cases show is that the Commission is very much focused on keeping up its enforcement activity to fight against greenwashing. But beyond cases in which companies may have used sustainability as a cover to engage in collusive arrangements or abusive conduct, there's clearly a need for companies to, in some cases, to cooperate if we are really to move the needle in the fight against climate change. Clearly, competition law cannot be the primary tool in promoting sustainability. That role belongs with regulation, but unfortunately regulation, as we all know, takes time to develop, to adopt, to implement, and we don't really have the luxury of time when it comes to climate change. Also, unilateral action can be effective, but sometimes it's not commercially viable. Much depends on whether consumers are willing to pay the higher price for more sustainable products, and the impact is likely not to be sufficiently broad. So this means that in many cases it is necessary for businesses to work together in order to achieve sufficient scale and also to overcome the so-called first mover disadvantage. So this raises an important question and an urgent question to my mind on how businesses can cooperate within the bounds of competition law. Clearly businesses need the ability to assess ex ante whether a proposed cooperation will lead to an antitrust risk. And the Commission has responded to the call from the industry for additional guidance on how sustainability agreements should be assessed under competition rules. As Emilio mentioned, the Commission has included a chapter dedicated to the assessment of sustainability agreements in its revised guidelines. The draft guidelines were published in March of this year, and we're expecting the final guidelines to be published in the next few months. But I think it's fair to say that much of the initial momentum in this debate has actually come from the member states, and I think most notably the Dutch Competition Authority has been very vocal about the fact that it considers that a less timorous approach is called for, given that climate change is really an existential crisis on a global scale. And so the ACM itself published its own set of guidelines. Also, other national competition authorities have joined in the debate. For example, the Hellenic Competition Authority cooperated with the ACM and published a joint position paper on the issue. Also worth noting that Austria has changed its laws to make it easier for sustainability agreements to be exempted, although obviously the likely impact of this initiative will be limited, given that it only applies to agreements that do not have any cross-border effects on trade. So I would like to focus on the two sets of guidance that are most influential in the debate at present, so the Commission's guidelines and the ACM's guidelines. And there's clear alignment between the two agencies on some important points. First of all, the Commission guidelines recognize that cooperation agreements may be necessary in some situations to fill the gap that remains when residual market failures have not been solved through public policy or regulation. Also, both agencies agree that many agreements promoting sustainability goals will fall completely outside the scope of Article 101, and I believe that Jeroen will say a few words about this in his presentation. Perhaps worth noting also that there is an ongoing debate on the applicability of the Ancillary Restraints Doctrine to sustainability agreements. As you might be aware, the Court of Justice has found that certain agreements that restrict competition may still not infringe Article 101, where the relevant restrictions are ancillary to the achievement of a legitimate objective, so a public interest objective. I'm thinking here about the Albany, Mecca Medina, Wouters case law. And the Commission's guidelines suggest that the Commission does not consider that the case law, that this case law can extend to sustainability agreements. So it will be interesting to see if in the final guidelines the Commission will confirm this position. Indeed, I think on the one hand, there is a clear parallel between the objectives that were being protected in the relevant cases and sustainability. Sustainability and climate mitigation are key EU objectives. However, I can also see how there may be a risk of over-reliance by businesses on this doctrine to justify greenwashing. To my mind, a more flexible approach under Article 101.3 that actually recognizes the interaction between consumption and the environment would be more appropriate. So this takes me to the system of individual exemption under Article 101.3. And it is in the context of the application of this regime that the two sets of guidance, the Commission's and the ACM's, diverge in their approach. So I think it's interesting to really focus on the divergences because these are really the issues on which the debate remains open. So as you might know, Article 101.3 exempts agreements that whilst they are restrictive of competition, they also produce sufficient benefits in terms of improvement in production and distribution of goods or economic and technical progress. Where sustainability agreements are concerned, the one condition under Article 101.3 that has proven to be most controversial is the condition that requires that a fair share of the benefits are passed on to consumers. So this raises the question of what is a fair share and what benefits are actually relevant in the context of this assessment. The Commission says in its guidelines that benefits have to be related to the consumers of the products covered by those agreements. In particular, the Commission focuses on so-called individual use value benefits, so qualitative efficiencies such as improvements in the quality or diversity of products or price reductions. The Commission also takes into account other types of benefits, though this is to a limited extent because the Commission still limits its assessments to benefits going to the relevant consumers. In contrast, the ACM proposes in its guidelines that in certain circumstances, collective benefits, so benefits to society at large, should be taken into account. And specifically, the ACM suggests that this is appropriate in the case of so-called environmental damage agreements. So briefly, the ACM defines this category of agreements as including agreements that address the major causes of climate change and air pollution, and agreements that implement an international or national policy goal, such as, for example, the reduction of greenhouse gas emissions. So when assessing these agreements, the ACM considers that the polluter pays principle should apply. If an agreement qualifies as an environmental damage agreement, the fair share should take into account also benefits for society as a whole. So also out-of-market benefits and potentially also benefits in third countries. For other sustainability agreements, the approach suggested by the ACM is the same as the Commission. So the ACM considers that full compensation of consumers within the relevant market may be appropriate. So I just would like to conclude by noting that there are no obvious legal blocks for the ACM taking this approach and moving away from the full compensation of consumers principle. In fact, Article 101.3 does not require full compensation. It specifically refers to a more limited standard, a fair share for consumers. And I believe also that there is no case law mandating this approach. And in fact, I think there's a very interesting note by the ACM which analyzes the relevant case law and comes to this conclusion. Rather, the full compensation standard seems to come from the guidance and decisional practice of competition authorities, and so could also be changed by the same authorities. Perhaps also worth noting that before the Commission adopted its guidelines and even before Regulation 1/2004 was adopted, the Commission itself took into account collective benefits more broadly in the washing machines case. However, the debate remains open on whether, as a matter of policy, it is appropriate for competition law to look beyond consumer welfare, or whether, in fact, a broader definition of consumer welfare is needed that takes into account the current economic context and the very far-reaching effects of consumption on the environment. So I will leave you with that question, so some food for thought. And on this note, I am happy to hand over to Jeroen, who will elaborate further on the Commission's approach.
Everyone can hear me loud and clear. Perfect. Thank you very much for the invitation to Emilio and Francesco.
Oh, so I think the audience can't hear you very well. Can we do anything about the audio? Can I? Does it work if I move my microphone? Or is the audio? Could you try again, Jeroen?
Yes. Can you hear me now?
Yeah, kind of. I think you need to speak a bit louder, so if you can.
Try to speak loud. Is this loud enough?
Yes, thank you. That would be great.
Okay, I'll try to be louder than I normally speak. So thank you very much, Emilio and Francesco, for inviting me to this interesting panel on sustainability. I would like to briefly give a snapshot of what the Commission proposed guidance is on sustainability and sustainability agreements. So maybe first of all, to explain the notion of sustainability, which in our view, although the whole debate has been triggered by the European Commission's Green Deal and the objectives in terms of environmental benefit.
I'm sorry, but I suspect that the audience cannot hear you.
And così, no? No? Can you now? Okay, I think you can continue, and we'll try to sort out the issue. Mm-hmm.
Okay. So what I was trying to say is that while the whole debate on sustainability was triggered by the European Commission's Green Deal, which very much focused on the environment and the environmental protection, reduction of greenhouse gas emissions, the approach which we have taken in the draft revised guidelines is a much broader one, where sustainability doesn't only cover environmental benefits or environmental issues, but also social and other governance type of issues, which are often also referred to as ESG. So that's, first of all, I think, an important issue, that sustainability in our approach is not limited to protection of the environment. Secondly, as what regards sustainability or so-called sustainability cooperation agreements. And in fact, we see them as any type of agreement, cooperation agreement between competitors, which genuinely tries to pursue one or more sustainability objectives. They're not as such a different type of category of agreements, because they can take the form of any of the other types of agreements which are covered by the horizontal guidelines. Meaning, it can be an R&D agreement, it can be a production agreement, it can be a purchasing agreement, but also a standardization agreement, which in fact pursues a sustainability objective. In that sense, and that's one of the messages we also received through the public consultation, we might have to clarify better how this specific chapter on sustainability interrelates with the other chapters in the horizontal guidelines. Because, for example, if you have an R&D agreement which also pursues a sustainability objective, you will have to consult both the chapter on R&D agreements, because that's the framework for assessing such agreements, but for the sustainability aspect of it, you will also have to check and assess it under Chapter 9 covering sustainability agreements. So that's certainly a lesson or a takeaway we already noted from the public consultation. Now, secondly, what is important, and I think Francesca already alluded at it, in our view, many of the market failure or negative externalities which are caused in the first place will be resolved through regulation. As you know, the European Commission is putting on the table many proposals in this field to achieve sustainability objectives and to implement the Green Deal. So a lot will already be addressed through regulation. It's only where there's no regulation or where regulation still leaves some margin of maneuver that there's a complementary role, in our view, for cooperation agreements between competitors. And that's where, of course, this guidance or this proposed guidance kicks in, and where the framework set out, and which I briefly explained, is of much importance and should, in our view, and hopefully will, give more reassurance, more legal certainty to companies as to what they will be able to do in an easy way, meaning without a full assessment or under Article 101(3), or which will require in some cases a more deeply and detailed assessment under Article 101(3). So first of all, what we've tried to do, and I think indeed in that sense we also more or less are in alignment with what the ACN, the Dutch Competition Authority, has done, is we provided a number of agreements which in our view are falling outside Article 101(1). So there's no restriction of competition, there's no worry at all for companies to engage in such type of agreements. And that is, we have a number of examples in the guidelines. One of them is, for example, industry setting up a database of suppliers or retailers with whom they work, with whom they have experience, and that they know and probably even have audited in terms of their sustainable operations. Such a database and the sharing of those suppliers or distributors with others is not a problem, as long as, of course, no one is obliged to work or to cooperate with these. There's just a choice, a possibility, and a reassurance that they are working sustainably. There's also the example of raising awareness, so industry-wide awareness campaigns about sustainability and how to achieve it, which can be unproblematic and fall outside. Then, of course, you have a whole type of agreements, cooperation agreements, pursuing sustainability goals, which can affect certain parameters of competition, be it price, be it choice, quality, quantity, or innovation. And then, of course, you have to check more in depth whether there's a problem in terms of Article 101. But also here, in our view, there is some useful guidance in the drafts, which should at least to some extent reassure companies in several ways. And that's first of all, and maybe it's sometimes a bit overlooked, but I think it's quite important. Namely, if you are genuinely pursuing a sustainability objective, then the guidance which we propose indicates that what seemingly could look as something by object, because it involves price, because it involves quantity or quality restrictions, that it is not necessarily to be assessed by object. Because the fact that you pursue a genuine sustainability objective makes it shift in some way from a by object to a by effects analysis. And that's quite important in our view, because as you all know, based on, for example, the Expedia case law, by object infringements are always restrictive of competition, and there's no issue of appreciability. And so, I mean, if something switches from by object to by effect, there's already some more leeway in terms of assessment and some more possibilities in terms of achieving something. An additional issue which we have tried to clarify, that is that what in our view and from our experience in talking to industry and consulting more broadly, is that many of these sustainability initiatives which are being taken have to do with sort of standard setting. And it's about setting certain standards for production, for using certain inputs, but also for production processes, the products themselves, labeling them as sustainable or having some green angle. You know, probably from your own personal consumption, that you have these sustainability labels in terms of sustainable fisheries, but also in terms of woods, so certain furniture or wooden products which are labeled FSC. So you have these type of logos and labels, and those are being used more often. There's new ones being developed and or being expanded more broadly in the market. And we try to also provide a certain reassurance that these type of labels, these type of quality labels or standards can escape also Article 101.1 if meeting certain conditions. I'm not going to go into the details of the conditions, but there is a so-called soft safe harbor. If you tick the box of 7 conditions, then you should be assured that you fall outside Article 101. I admit there is one tricky condition, which has also triggered some comments in the context of the public consultation, namely, it should not lead to a significant price increase or significant reduction in choice. Of course, that triggers the whole debate. What is a significant price increase, and how easily is that being brought about? Again, here it's quite difficult to give some general reassurance. It depends very much on types of industry or types of sector. On the other hand, certain labels only apply to certain ingredients of products, which can only maybe represent a very small fraction of the eventual price, and therefore an increase in the price of that ingredient or input is not necessarily leading to a significant price increase of the actual product which is being put on the market. So also there, I think there's some scope for reassurance. Then maybe move to the next slide, please. Thank you very much. And then, of course, in some cases, I mean, you don't fall within the safe harbor for sustainability standards. You're not falling within the category of agreements which also fall outside the scope because they don't affect parameters of competition. You enter into 101. There is potentially appreciable negative effects on competition. What should you do then? And then we enter, of course, in the whole assessment under Article 101.3. I'll try to be not too long because the clock is ticking, I guess. Maybe let's focus briefly on the 4 conditions with a bit more attention to the second one. The first one is about the improvement of production distribution of goods or technical or economic progress. I think here what we've tried to explain is the type of efficiencies that we recognize. That's 2 broad categories, qualitative and cost efficiencies. These are the traditional ones. I think everyone is quite aware of what is meant. We try to give some more guidance what is can be covered, but I think this is less controversial. The second condition is, of course, the much more controversial one, the one which Francesca already highlighted, as could be seen as sometimes not entirely consistent or convergent within the EU, especially with the draft guidelines of the Dutch Competition Authority, which can be seen as going a bit further than what we propose. But what do we propose? In fact, we recognize 3 ways in which consumers can be beneficiaries of what is being done by companies. In the first category, what we call an individual use value benefits, it's in fact through the actual use of a product that a consumer receives a benefit. So by consuming the product, he feels or experiences the benefit of what is being created. That is, again, non-controversial. It's something which is traditional and well-known and has been used in the past. We added an additional category, which is called the non-use value benefits. Sometimes my colleagues refer to this as the sort of warm glow feeling which certain consumers can have or can strive for. Namely, you're not in fact having or experience a benefit through your proper use of the product, but rather through what it brings for others. So the benefit that it brings for others and that you appreciate in a product and are willing to pay for is also being recognized and being accepted as a sort of benefit. That is something which is, I think, quite new. Okay, there can be criticism in terms of what this willingness to pay entails, how you can prove it, whether it's easy or not, the type of evidence, but that's something, I mean, we will have to look into in practice when concrete cases are being put forward. At least it gives an opening of what is possible. And then we have probably the most new and controversial part, and which is still maybe also at the same time not entirely seen as fully beneficial or opening enough the assessment that we have in mind. But in our view, it's already doing something substantial, namely recognizing that there's also types of collective benefits that we can accept as a benefit that is also shared with consumers in the relevant market. And here we're talking about all types of collective actions which reduce negative externalities and address certain market failure, and which are necessary through collective action and are not being done through individual action by consumers. We've given 2 examples in the draft horizontal guidelines to illustrate a bit what we mean. There's one positive, one negative example. The positive example is about new fuel, which is less polluting. This is not only benefiting the driver of the car, namely the consumer of the fuel, but also the reduction in pollution will benefit citizens at large. Now, if in this case there's a substantial overlap between the consumers of the product and the beneficiaries, the wider beneficiaries of these benefits, then these can be taken into account and also contribute to the fair share criteria. On the other hand, if there's no substantial overlap between the consumers of the product and the wider beneficiaries, then of course it cannot be taken into account, and it will not contribute to the meeting of this condition. Now, what is also important to know that there can be a combination of the three. So you can have the three aspects combined in one type of situation, where the use of the product, for example, take the fuel, is better for the car, and so it immediately benefits the customer of the product. But it also is appreciated by the consumer as benefiting other people, other citizens in society, in the streets. And at the same time, there is some collective benefits coming from it. So that can be a combination of the types of benefits in the assessment. I also should add, that of course the benefits need to be significant to outweigh the negative effects. And sometimes this can be quite obvious on the face of it, so then doesn't always need to be some detailed or economic quantification of the benefits. It can be already clear on the face of it. Of course, in certain situations, there needs to be a more detailed explanation or a quantification of the benefits, but that depends on a case-by-case situation, and we're, of course, open to discuss this with companies and to see in actual case situations how to approach this. Then you have the issue of indispensability, maybe the last thing I briefly touch upon. It recognizes explicitly one of the issues which Francesca also mentioned, namely the first mover disadvantage. So we're also willing to take this into account. We do also, of course, warn companies that normally, if there is consumer demand, companies should work to this and address this individually. I mean, there will be rewards for the efforts they do to meet that demand. They don't necessarily need to cooperate. And also, again, if there's regulation covering the issue or addressing it, then there's probably, in our view, no need necessarily for cooperation, or maybe cooperation only to achieve something more cost efficiently, and maybe something to be discussed and also has been raised in the public consultation, whether doing something faster than what is foreseen in regulation or spearheading what is coming up as future regulation maybe can also be taken into account. I'm not going to address the fourth condition because that's quite straightforward. There should be no entire elimination of competition. And now, just as some closing remarks, we are finalizing the work on the revised draft guidelines. It may maybe take a little bit more time than initially foreseen. People who are subscribed to MLEX will maybe have noticed that there is probably a small extension foreseen of the current block exemption regulations, and therefore also the guidelines will be replaced a little bit later. But I mean, that's all to serve legal certainty for companies and to do a proper and thoroughly well thought through revision. In the meantime, the Commission as well, and especially also the NCAs, are building up case experience. You have, for those who have subscribed to the Dutch Competition Authority's news alerts, will have seen that they have at least done, I think in the meantime, 4 or 5 cases under their drafts guidance. So they're building experience, and unsurprisingly to all of you, I hope, within the ECN we do discuss and exchange views. So even if we don't necessarily agree always on everything, we discuss, we exchange views, and that's something which can only benefit every one of us. And for example, the German authority also has some cases which can be interesting as an example. And then finally, in terms of the future, and especially also in terms of legal certainty or reassurance for companies, there is maybe also a link here with another revision which is coming to an end and should soon be resulting in the publication of the revised informal guidance notice, where the criteria for providing informal guidance to companies will be softened a bit, and which will allow companies to also, in the area of sustainability, seek informal guidance from the Commission in areas where there's insufficient or no clarity on the issue. So I'll stop here, and I think I have spoken far too much already, but just to give you a snapshot of what's happening at EU level. Thank you very much.
Many thanks, Cyril. Very interesting. Now we'll pass. Oh yes, of course. And okay, perfect. Thank you. Please mindful of the time. And
good afternoon. And thank you, of course, for the great introduction. I hope you can hear me. So the panel has already summarized perfectly the state of this area of where we are. And already touched on some interesting topics which we can explore in the Q&A. So what I want to do is to make the most of my 7 minutes to focus on 3 main points that I think are particularly interesting in terms of what are the challenges of integrating sustainability within the competition analysis and how they can be overcome. So a first point I want to make is how crucial it is. This is like really super important. Before thinking about any sector exemption, any public interest considerations, or even about externalities, to use our current framework fully. So on the one hand, there are plenty of opportunities, and we just heard about this, within the traditional framework to conclude agreements that can benefit the environment as well as market competition. Cooperation agreements that can lead to substantial benefits that are economic in nature as well as good for the environment. And what do I mean by this? I mean surely reduced energy and environmental costs, but also certain types of rationalization efforts, pooling know-how, and everything that enhances the green quality and innovation of the product. And this is all, or should be at the very least, recognized under the block exemptions or under a 101(3) type of analysis. And we can also think a lot more positively, and the European Commission is going a little bit in this direction, about cooperation that are aimed at overcoming market failures. That's very important, such as the first mover disadvantage, but also creating sustainability markets, which is nothing new, but perhaps a little bit underrated, and facilitating investments in green processes and technologies. On the other hand, and I cannot but mention this, it's also important to recognize that there is a little bit of a trend of competition authorities, in particular those that are more advanced and more active in this area, to focus on what they can do with their framework, in particular with their enforcement tools, but also with market studies and advocacy for the environment. So if you implement a greener process or technology, or you save on raw materials, and that leads you to lowering your costs, so sustainability actually lowers costs, competition authorities can simply sort of preserve competition on prices, on which they have a lot of experience, to do something good for the environment. And in the cartel investigations on the price of ethanol, one of the press releases was issued this last July. It quotes Vestager saying, "We are concerned that the companies conducted harm competition in a market for the supply of biofuels, which contribute to the reduction of greenhouse gas emissions. With artificially inflated biofuel prices, Green Deal objectives are also undermined." So this seems to me to suggest that it can be a relevant factor for prioritization, which is quite important for the business, and this will be increasingly important for companies to, from the perspective of compliance, of course. Similarly, and a little bit less explored, is also the prohibition of cartels where companies refrain from competing on green quality and green innovation, and that is why we are beginning to see those cases. Francesca mentioned it just earlier, the notable AdBlue case, where car manufacturers were fining for colluding to slow down fuel cleaning technologies, the development and implementation of them. But the most complex cases, of course, and this is well recognized, are those where competition and environmental harm and benefits do not really go in the same direction. There's a conflict or a clash. Which brings me to the second point of out-of-market effects. And this is a very complex issue because environmental protection and sustainability, broadly considered, really is characterized by externalities. So not only we have the problem of determining what type of effects we can consider, because we discussed quite a bit about greenhouse gas emissions, but can we also consider water pollution? Can we also think about biodiversity loss? And where do we draw the line? Is there any line? But also we have the difficulty of determining whether the positive effects of an agreement on sustainability need to affect the same category of consumers and to compensate even only partially for the anti-competitive harm. So a reduction in greenhouse emissions necessarily is shared among citizens and the broader society. It's not felt by an isolated group of consumers. And then sometimes benefit don't only accrue to another category of consumers, but also to future citizens. They are not felt immediately, which is even more complex. And so the European Commission draft horizontal cooperation guidelines uses this mechanism of no-use value benefits. So just to remind, the value that the consumers would derive indirectly from the quality of the product that doesn't necessarily come from its consumption. Or its direct benefit. Say a washing powder that is less polluting, doesn't pollute the water as much as others, the effect of which may be felt by other consumers, but are important to me as the buyer. So I think that this approach is very robust, because in my view it is important whenever possible to try to interpret this parameter on non-use value as consumer or a form of consumer utility. So an element of the quality of the product that the consumer values, even if it's not tangible, even if it's not related to its own consumption. And while in principle I am open to the idea of recognizing societal benefits at large, I think this is the best way to bring the analysis back into the traditional framework, also to make it more workable, to link it to even at a step, even remotely, let's say, even at an arm's length, but to the willingness to pay. And this is not only because it preserves legal certainty, so it is in alignment with the case law, but also because otherwise there is a very thin, that is almost indiscernible line, I think, between non-use value and all sorts of externalities. And those are positive and negative externalities. So unless it is the government that sets a very clear policy direction, or there is an international standard, let's say, I do see a risk that this opens a Pandora's box that makes administrability very difficult. And I'm not just mentioning this for competition authorities, but also for businesses. That said, whichever way we are deciding to go, I do think it's particularly important to clarify and come to a convergent approach, at least among European member states, to avoid forum shopping kind of phenomena. And I think this is a particularly crucial point in the light also of the publication of the final guidelines. My third and final point, so considering sustainability into the competition analysis will necessarily require some adjustments to our current framework. And one of the main and most important ones, in my view, is the way in which we think about the future and in the way in which we think about time in the antitrust analysis. So antitrust measures often promote short-run economic efficiencies that we know by focusing on price competition to push prices toward marginal cost of production. And while this is like a really excellent proxy for the functioning of most markets, we also need to be aware and very present to the idea that it doesn't always give us the full picture, and that what happens in the long run sometimes is at odds with short-term effects on choice and quality. So it is important that competition authorities start to think about the dynamic effects a lot more to have a broader, like a fuller picture of what is happening. And that is where I believe there is a lot more room, also particularly with economists, to do more thinking. Sustainability, harm, and efficiency can manifest in a much longer time frame that we are typically used to measure. And the classic example is like industries with long investment cycles. And so for horizontal agreements, we may have to look at the long-term effects, and this is important. Also become more comfortable with the uncertainty that necessarily invites into the analysis. Let's say that necessity shouldn't be a function of the feasibility, of the complexity of the assessment. And I conclude, I think there is a lot that really competition authorities can do, and business that can use the framework in a way that that is fuller. The legal framework is, in my mind, flexible enough to allow us to do that. And I welcome very much all the initiatives that the competition authorities, like the European Commission, the Dutch, and there's a paper by the Bundeskartellamt. There's a lot of effort by the Greek competition authorities to think and give more attention to other important aspects of the analysis, even if it's difficult. So without losing focus of our main core sort of like North Poles, without losing sight of allocative and productive efficiencies in the long term, there is a significant margin to explore a lot more the ways in which competition really, as it is, can facilitate the green transition. And in my view, that's the way to go, or at the very least, be absolutely sure that we are not an impediment.
Thank you very much, Cristina. Please stay with us because I promise that the intervention of Susanne will be super interesting.
I think I have to. Can you hear me?
It should be on already.
Should be.
It's on.
It's on. Okay. Good. So could you please turn the slide? So even if you're not sure after the introduction of this morning if the more economic approach is in good health or not, I think we will need it to overcome the challenges we have with antitrust and sustainability. And I've just brought some little pictures to remind you of the state the planet is without going further into detail. And I think one important starting point is, if you would move to the next slide, that also companies are aware of this. There is a lot of microeconomic study which is assuming that companies try to maximize profits and it's all about shareholder value. But the pre-assumption of these studies might also influence the outcome. And I think we have to realize that also companies are driven now by expectations of their shareholders and finance. Think of the Norwegian pension fund withdrawing from certain investments which have to increasingly meet ESG or sustainability criteria, and being part, for example, of the Dow Jones Sustainability Index, as we are, for example, is a key element for doing business and getting finance. On a second change is that there's increasing environmental litigation, so companies might even be forced by court decisions, like in the Netherlands, Shell has been forced to reduce CO2 emissions. And then if you look across the globe, there's different regulation, and Sharon said that the regulator will address a lot of things. Yes, maybe in Europe, but in other places not, and business is mostly global. So there's an increasing difference in speed in regulation, and also there's a difference in how other companies perceive or define their sustainability strategy. And coming from the business to business and not the business to consumer industry, as a manufacturing industry, you have to look at what your customers want, and there you can see quite a lot of differences between ambitious sustainability targets you also as a supplier have to meet and others you don't. And so in this environment, I found one poll which is 2 years old, but still I think reflects the picture quite well, where 90-70% of the companies said that they need to cooperate on achieve sustainability goals, but more than half, 57%, had the perception that competition law is kind of hindering them in achieving the goals. And talking, for example, to our sustainability team, they all say, yeah, but we have to be careful and so on. So there's a fear which needs to be overcome not to infringe competition law. And I think in particular, and we have talked about this with regard to 1013, if it comes to market failure, it's most difficult because negative externalities are not priced in conventional products. So I have brought a few examples where we can see, and this is from the perspective of the manufacturing industry, where there's trouble. First of all, and what's mostly now up, is with regard to information exchange. There's a lot of information exchange with the French or the German Supply Chain Act, the new initiative of the Commission on Corporate Sustainability Due Diligence. And there's a lot of information exchanged. Also, if you look at carbon footprint calculation, and for example, the greenhouse gas protocol, there's a lot of detailed information you need from your suppliers to calculate your carbon footprint, and this goes to your tier 1, tier 2, tier 3 supplier. And in this context, a lot of information is exchanged. And here, still looking at the Commission guidelines, you find that competitively sensitive information must not be exchanged. And of course, there's a classical way how to overcome this, and by drawing firewalls or clean teams in certain situations. But it would be nice to have some more guidance or safe harbor here from competition authorities in order not to run into trouble in this, in particular if the information exchange goes beyond what's legally required according, for example, to the German or French Supply Chain Act, but if customers want more. And here also the Commission says in its guideline that these customer platforms, which want to track along the supply chain sustainability, are kind of okay, but in another part, and Sharon said this, that there needs to be more alignment between the sustainability part and the other part. They still say that any supplier or supplier-related information outside the purchasing consortia is competitively sensitive. So I think here some safe harbor would be nice. If you talk about label standards, this has mostly been addressed from a consumer industry point of view, and many cases we see are on these fair trade labels or things. If you go to the manufacturing industry or the whole production supply chain, this is more difficult, and then you will need to maybe, and for example, you could think of, because recyclability is a big topic in the industry, you could think of a digital pass, but this would require, because if you have certain materials in plastics, you can't recycle. So you would have a kind of agreeing on that pass on a non-use of certain materials, and as long as they are legally permitted and they are not hazardous and you can sell them, if you go for such a digital pass on products, you need to take care that you're not running into boycott of certain conventional products which are not recyclable. And there, the guidelines are at the moment so far silent. Also with regard to joint purchasing, you could go beyond just buying sustainable raw materials, where still you could, even if they're more expensive, find some efficiencies by building a joint consortia and solve this under the current framework. But what you can see more in the industry is that those who are front runners and have defined ambitious targets and want to source only sustainable require their whole supply chain to buy these sustainable products, and then it gets a bit more difficult and tricky to interpret how in the given framework you can get this compliant. There are other examples with regard to cooperation, and here of course there is phasing out of unsustainable products. This comes a bit again to this digital path for recyclability. If you really want to phase out products and you want to do this large scale in certain production processes, you will have automatically big competitors cooperating on that. For example, there is under the roof of the World Economic Forum an initiative of the chemical industry on lowering carbon emissions to net zero in 2050, but this will require really changes of the production chain. And just to give an example that if you look, for example, you can see this with ethylene, which is you get ethylene and propylene out of a cracker, and then you have the full supply chain of ethylene oxide, polyethylene, styrene, and all kind of plastics. And there, at the moment, there's an offering in the market, and this will not get cheaper, that you do this not out of the cracker and oil, but you do this from old tires or from metal oil you collect and then try to go back in this chain to get the ethylene, which is a basic chemical to get really to a full set of products we are all using in daily life. And there the price, and you can observe this, and this is public in the market, is double. So by just replacing this by old tires or recyclable metal oil, you get a double of price, and even if this would be maybe a small component ultimately of a consumer product, it's quite difficult because this is doubling. And this brings me to, there's a lot of discussion about willingness to pay, and we can see in the guidelines, Sharon, that for the non-use value benefits, so feeling better, actually you're requiring a willingness to pay. But this is something which is done for consumers. So there's survey, and there's even their difficulty to do it in the right way, but this can't be done in the supply chain, so from business to business, because there is no recognized economic method to do a willingness to pay test with other companies buying intermediates in the raw material chain. And the difficulty here is, if I'm asking you all as a consumers, would you be willing to pay 20 cents more for a fair-traded banana, you will have a reply. But if you're asking, for example, companies, would you be willing to buy this and that 20 cents more for a certain intermediate you're using in your production, this will totally depend on whether you can pass on this increased cost to your customers. So you can't do the classical willingness to pay, and you will have trouble to show actually that there is a benefit, and this will lead you to the collective benefits. And then you are in between the Dutch authority and the Commission, and whether and how this can be recognized. And this is quite tricky. I think we have not yet really seen the cases. There's a recent case of the Dutch authority about storing carbon dioxide in old North Sea gas fields, which is quite interesting, and I recommend to read. There you can see it, but otherwise they are not that big cases. But I think here we will get to a real challenge because we would have kind of automatically an increased price, because sustainability also comes along with a cost, and we would have to look for collective benefits, because in a business to business we can't do the willingness to pay test. And ultimately, just to mention before I come to my discussion remarks, also the relevant market definition is quite difficult because it's not clear, and there are a lot of safety harbor rules would apply depending on your market share. How to define a relevant market? Is a sustainable product always a different relevant market? Can the usual test, if you have a small but insignificant cost increase or significant 5% over months' time, can this be an answer to whether the product is substitutable or not with regard to usually more expensive sustainable products or not? And ultimately, if we look at acquisitions, I've just read a newspaper article last week about we have 300 million plastic waste per year. This was increased by 8.2 million by all the plastic waste we had in the corona crisis. And there's a lot of this blue wrap material used in hospitals, and there was one Dutch company inventing something how to do out of this blue wrap, where surgical instruments are packed in, a chair. So just pulling an example, if now somebody in the plastics industry wouldn't be very much amused about this, would try to acquire this little Dutch company, would this be a killer acquisition? Would the authorities look at this and put this, for example, under the Article 2 referrals, 22, if it's too small and below the thresholds or not? Or could that be also, and this is a question I think we will have to ask in many cases in the future, the breakthrough for this technology of this little company building more furniture out of plastic waste we had during the Corona crisis. So ultimately, I think the three key questions we have to answer. You can, in the interest of time, I think, move on to the next slide.
No.
They're missing.
They're missing because we thought it was for the discussion.
Don't
worry.
Okay, good. So, but summarizing this, I think one question we have to ask is, do we want to treat climate neutrality different than other ESG targets, like, for example, animal welfare or not? We can see that the Dutch authority decided to do that because they're treating environmental damage agreements differently than other also important targets. The next question is, would consumers to be really willing to pay more for a more sustainable product? So will you have this Apple effect that they're all queuing up in front of stores to buy the more expensive sustainable products? And ultimately, if it comes to 1013, could we maybe if we don't look at the collective benefits, could we try to get the external costs in by increasing the price of the conventional product and then comparing it with the sustainable product? Because there's a lot of literature now in environmental economics, and the colleagues, the economists, are able to calculate these costs in. And so if you really compare and we have a price increase for the more sustainable product, should we compare that maybe to the conventional one, plus the external costs, which are actually not priced in as a factor in the cost the consumer or the business consumer pays for the product? So,
No, thank you very much. Super engaging conversation, and obviously we are well beyond the time limit. So we have, I think, just one question for Jérôme from the European Commission. Not from Jérôme, not for the European Commission, obviously, but we're curious to understand the different approach that you are suggesting in comparison with the Dutch Antitrust Authority, which is not to take into account the out-of-market benefit. And so reading a number of articles from economists, from academia, from professors, from lawyers, from practitioners, the idea is that if we don't take into account the out-of-market benefit, it will be very difficult to allow and to authorize sustainability agreement which could have a real impact. So this, I believe, it is a very interesting question for the audience. So up to you.
Thank you, Emilio. You're going directly to the heart of the debate, I think. Well, let me say that our approach in terms of collective benefits is at least to some extent opening up, in the sense that we do accept through this approach. Yes, sorry. So in our view, collective benefits recognition already opens up a bit towards so-called larger benefits for society. But it does still require a link with the relevant market, and that is because, in our view, and through our established enforcement system, which has been upheld by the court, we have to look not at competition in the abstract, but look at an analysis of competition within a relevant market. So we cannot really depart from this, but through the collective benefits, we accept that certain benefits which are not occurring within the relevant market can be taken into account as long as they substantially overlap with the consumers in the relevant market. And the reason that we stick to this is also because it's, as I said, based on fundamental principles of competition enforcement, but it would also oblige us, the Commission and the national competition authorities, to take into account the whole area of interests which can be brought up and where competition authorities are not really well placed to balance those types of interests with the protection of competition. And we feel that, therefore, and that's also a link, I think, what I said before with regulation, that the legislator and the democratically elected parliamentarians are much better placed to do a democratic weighing of interest and to take a decision on this. And finally, I think in our view, competition still also has a very important role to play in the whole sustainability progress, in the sense that, in our view, competition spurs innovation, and we need this innovation to be able to improve on sustainability aspects in all types of sectors. So I think that's a bit where we stand and why we haven't moved as far as certain people would want us to move. Thank you.
Thank you to you. Fair enough. I think we need to